Imagine you're a business owner in Texas who signs a contract with a California company. If a dispute arises, which state's laws apply? This question lies at the heart of conflict of laws principles, a crucial legal framework that determines which jurisdiction's rules govern cross-border disputes. Conflict of laws refers to the set of rules used to determine which law applies when two or more contradictory laws could potentially govern a legal dispute. These conflicts can arise between federal and state laws, between different state laws, or between the laws of different countries. As our world becomes increasingly interconnected, understanding these principles has never been more important. When courts face competing legal rules, they follow specific processes to determine which law to apply. For procedural matters, courts typically apply lex for-i, or the law of the forum where the case is being heard. For substantive matters, they often use lex logii, applying the law of the place where the cause of action occurred. This distinction helps courts navigate complex legal landscapes. The roots of conflict of laws principles stretch back to ancient Roman law, where legal scholars needed to address disputes across the vast Roman Empire. These concepts evolved through medieval Europe and gained particular prominence during the 19th and 20th centuries as international trade expanded. Today's principles integrate aspects of both common law and civil law traditions. Several key doctrines guide modern conflict resolution. Governmental interest analysis examines which state has the most substantial interest in applying its law. The most significant relationship test determines which jurisdiction has the closest connection to the case. Other important approaches include comparative impairment, the Renvoi doctrine, and the public policy exception, which allows courts to reject foreign laws that contradict fundamental local policies. In practical terms, many business contracts contain specific provisions addressing potential conflicts of laws. For example, a contract might explicitly state that Texas law governs the agreement, even if the cause of action occurs in California. These clauses help businesses create legal certainty and avoid unexpected jurisdictional surprises. The United States presents a particularly complex environment for conflict of laws. Since each state has its own legal system, conflicts frequently arise in interstate commerce. A landmark 1938 Supreme Court ruling established that federal courts must follow the conflict of laws rules of the state in which they are hearing a case. Additionally, the Constitution's full faith and credit clause requires states to respect and enforce judgments from other states, with limited exceptions for penal law matters. On the international stage, conflict of laws principles facilitate global commerce and dispute resolution. Multinational corporations rely on governing law clauses in their contracts. Courts use treaties like the Hague Convention to determine jurisdiction and enforce judgments across borders. Family law issues such as international custody battles often involve balancing the interests of different legal systems. Human rights cases may require reconciling domestic laws with international treaties. Different legal systems approach these conflicts in distinctive ways. United States courts rely on state-specific approaches and the restatement of conflict of laws. The European Union has standardized many aspects through regulations like Rome I and Rome II. The United Kingdom applies common law principles while adhering to relevant international treaties. Civil law countries like France and Germany emphasize codified rules over judicial discretion. Understanding conflict of laws principles is essential in our interconnected world. Whether you're drafting a business contract, handling an international dispute, or navigating family law across borders, these principles provide the framework for determining which laws apply. By establishing predictable rules for resolving jurisdictional conflicts, they help create legal certainty in an increasingly complex global environment.